Welcome to Real Estate Salesperson's, aka RES, Exam Prep. I'm your host, Damien, here to make tackling the Singapore property market for your exam a little less daunting and maybe even a bit fun.
Hi everyone, I'm Serene and I'm geared up to dive deep into the specifics you need to ace your RES exam.
That's right. Today, we're laser focused on the sale of completed private properties in Singapore. Think of this as your express lane to understanding this crucial topic. We've got like a really comprehensive set of notes here. And our mission is simple. Pull out the vital info that will help you confidently answer those exam questions. We're talking everything from your responsibilities, potential pitfalls, the nitty-gritty of the sales process, even the lowdown on strata title developments. So if you're ready to boost your exam prep, let's get started.
Excellent. Let's jump right in with the foundational concept, Caveat Emptor. Sounds, very official, but what does buyer beware really mean for our future real estate professionals and their clients?
Okay, buyer beware. It's like the golden rule of property shopping, isn't it? Basically, the responsibility is on the purchaser to do their due diligence.
Yeah.
And for you, as a salesperson, your role is to strongly advise your buyers to verify who actually owns the property
Right.
and to check if the seller is bankrupt before they even think about putting down an option fee. It's like a crucial look before you leap signpost.
Exactly. A key insight for you here is that while your main duty is to your client, the vendor, you must advise the purchaser to do these checks.
Absolutely. For their own protection.
Precisely. And remember, while you guide them on how to check, you can't definitively declare a title as good or having defects. That's where the legal eagles, the lawyers, come in.
Right. Yeah.
But what exactly constitutes a defect in title? It's any factor that could potentially invalidate the ownership.
Right. A defect is anything that could throw a wrench in the works, make the ownership less than secure. Issues that make the title questionable, really. Spotting these early is crucial.
Yeah.
Some buyers might wisely get their solicitor involved right away to investigate thoroughly. That proactive approach can save a lot of headaches.
Exactly. Now, here's a point that might seem a little counterintuitive at first. As the salesperson representing the vendor, you don't actually owe a duty of good faith or loyalty to the purchaser.
That's a really important point. Like, burn it into your memory for the exam. You're acting for the seller, so your allegiance is with them. However, and this is a critical however,
Yes.
if a potential buyer directly asks you a specific question about a property's condition, you absolutely must answer truthfully. No wiggle room there.
None whatsoever. If you state something as facts say, you mentioned the aircon was just service, when really it's on its last legs and that's false, you could be held liable for misrepresentation.
Oof.
So while you aren't obligated to proactively disclose every minor issue, you cannot give false information when asked directly.
So it's a delicate balance then. You don't need to offer up every detail unsolicited, reinforcing that buyer beware idea, but you absolutely cannot mislead or lie if directly questioned.
Right. It's like being asked if you've seen a ghost in the property. If you have, you probably should mention it truthfully, though that's definitely outside the usual scope of property defects.
A memorable, if slightly spooky, analogy. This highlights why it's so vital for purchasers to be diligent. Encourage them to inspect thoroughly, ask plenty of questions.
And maybe consider hiring a home inspector, although, as our notes say, this isn't as common here in Singapore.
Right. And during these inspections, buyers need to distinguish between, enthusiastic puffery. This apartment has the most stunning city views, which is clearly opinion, sales talk.
Versus a concrete statement of fact like, the building underwent major facade renovation last year. That should be verifiable info.
Precisely. A salesperson saying, this kitchen is modern and stylish, is subjective. But if they knowingly conceal, say, a mold issue when asked about dampness.
That's a different ballgame altogether. Could lead to accusations of misrepresentation, even fraud, and the courts will even consider the experience of both parties.
All right, so buyer beware. But sellers and agents still need honesty when answering direct questions. Now, shifting to the seller side, what duties do we have in verifying their legal title?
This is fundamental. You must exercise due diligence to verify legal ownership. It's crucial to prevent payments going to the wrong person. Failing here is a serious breach, a CEA violation.
Well, definitely don't want that.
Yeah.
So where do we conduct these ownership searches? Make sure we're dealing with a legitimate owner.
Okay, a couple of key places. First, the IRS evaluation list that can be useful. Second, and more direct, is SLA's Integrated Land Information Service, in NLIS. The link is http://inless.gov.sglsf.sps.sps.strservice, Linsen Stare Service, Linsen Stare Product.
Anchor link.
Yeah, bookmark that one. And importantly, also conduct bankruptcy searches on the owner.
Bankruptcy search is another vital check. Why is that so significant?
Well, if the owner is bankrupt, the official assignee of the OA takes control of their assets. Any income must be disclosed to the OA. So, if your search shows the vendor is bankrupt, you must consult the OA or get legal advice before any money changes hands with the undischarged bankrupt. Avoids legal mess later.
Makes perfect sense. Don't want to get tangled in bankruptcy stuff. And where can we do these bankruptcy searches?
Conveniently online through the Ministry of Law's website. The address is https://www.mlaw.gov.sg/servicesio. And payment can be cash card, credit card, or direct debit. Pretty straightforward.
Excellent. Now let's talk about something RESPs should keep their hands off, literally transaction money.
Yes, very clear rule. Salespersons in Singapore are strictly prohibited from handling any transaction money for any party. Option fee, deposit, stamp duty, sale proceeds, none of it.
So absolutely no acting as a middleman for funds, even if a client offers.
Exactly. The only very specific exceptions are things like valuation fees, your commission, maybe minor repair bills, and only with written authorization from the vendor.
Okay.
Without that written permission, hands off the transaction money pot.
So if a buyer tries to hand you a hefty check for the deposit, the correct response is?
A polite but firm, "Thank you, but I'm not permitted to handle transaction money. These funds need to go directly to the vendor's lawyer or as per the OTP. Non-compliance is a serious offense under Part 3, regulation of estate agency work. Avoid it."
Got it. Transaction money. Look, don't touch. Now, legal requisitions. What happens in the background, legally speaking?
Legal requisitions are standard, essential. Basically, formal inquiries by the purchaser's lawyers to various government agencies. They're looking for encumbrances, restrictions, issues affecting the property, like a background check on the property itself. They mainly use the Integrated Legal Requisition System, InterRec, for efficiency.
InterRec sounds useful. Which government bodies get these requests? Gives us a sense of the scope.
It's broad, covers key regulators. IRS for tax, LTA for roads and transit systems, NEA for environment, Pub Sewerage Department, BCA for building safety, URA for planning, basically anyone with relevant info.
A really thorough sweep for red flags then. What if a law firm doesn't have InterRec access? Are they stuck?
Not entirely. They can still submit through 2 Crimson Logic Pete Ltd service centers. The notes give addresses, Supreme Court and Bugis Junction office tower. So there are alternatives.
Excellent. Now let's pivot to something with big consequences, misrepresentation, and your potential liabilities as an RESP.
Right. Misrepresentation, simply put, is a false statement of fact or law that persuades someone into a contract. If a statement made during negotiation turns out untrue and the buyer relied on it, it could lead to legal action.
Okay.
Important to distinguish a representation, a statement, to induce the contract from a term of the contract itself. And there are 3 main types of misrepresentation to know for your exam.
Okay, lay them on us. What are the 3 flavors?
First, innocent misrepresentation. This is when the person making the false statement had reasonable grounds to believe it was true, no intent to deceive.
Okay, an honest mistake.
Pretty much. The main remedy is usually rescission, like a hit and undo on the contract, puts everyone back where they started. But the court can award damages instead if that seems fairer.
Okay, so innocent.
But
what's next?
Negligent misrepresentation. This happens when someone makes a statement carelessly, without reasonable grounds to believe it's true, didn't check their facts properly.
Ah, carelessness.
Exactly. Under common law, this can lead to damages for the injured party to cover their losses.
So not being careful enough with info. And the third, most serious type, fraudulent misrepresentation, I guess.
Fraudulent misrepresentation. This is making a false statement deliberately intending to deceive, knowing it's untrue, or being reckless about its truth.
Yikes.
Remedies are most severe, damages and rescission. The injured party could also potentially sue the person in tort, which is a civil wrong.
Ouch. Deliberately lying has serious repercussions. Okay, let's shift to the actual process. Selling a completed private property in Singapore. What does that generally look like?
It's a sale by private treaty in the secondary market. Means vendor and purchaser can freely negotiate terms in the option to purchase. It's about reaching a mutually agreeable deal.
Negotiation is key then. And the paperwork, transaction forms.
Correct. Many agents use templates, but caution is crucial. If forms aren't handled right or have unsuitable clauses, it can lead to big problems. Monetary loss, even negligence lawsuits against you. Always double check and understand the forms.
Good warning. So what's typically the first formal document when a buyer is serious?
That would be the offer to purchase. The buyer's initial formal expression of interest, outlining their proposed terms. Now, you often see subject to contract in this offer. What's that mean?
My understanding is subject to contract means even if the vendor verbally agrees, there's no binding deal yet. The formal legal contract, usually the OTP, still needs finalizing and exercising. It's preliminary, not the final handshake.
Very accurate. However, there's also the special condition that can be in the offer. How does that differ?
A special condition sets specific requirements that must be met. Unlike subject to contract, these become legally binding once the condition is fulfilled. It protects parties from backing out once the condition is met.
Right, like subject to satisfactory replies to legal requisitions.
Exactly. Once those replies are clean, both parties are generally bound by that condition. Or, as the notes mention, maybe subject to SLA approval for a PR buying landed property. Once approval is granted, the condition's met.
Precisely. Now, after the vendor accepts the offer, what's the next crucial document?
That pivotal doc is the option to purchase, the OTP. Once the vendor accepts the offer, they issue this signed OTP to the purchaser.
And what right does this OTP grant the buyer?
It gives the buyer the exclusive right or option to buy the property at a pre-agreed price within a specific time frame, the validity period. To get this right, the buyer pays an option fee, usually non-refundable, often around 1% of the price.
Okay.
If the buyer wants to proceed, they must exercise the OTP within that period, usually maybe 14 days.
And what happens when the purchaser exercises this option? What's involved?
Okay, they get the OTP, review it carefully. If they proceed, they sign the acceptance section within the validity period that's exercising it. Usually their lawyer witnesses this, and at this point, they also pay the rest of the deposit, the exercise fee, bringing the total deposit to maybe 5% to 10%.
And this act of exercising, that's when it becomes legally binding on both sides, right?
Absolutely. Once exercised properly, the OTP becomes a legally binding contract for sale and purchase.
Yeah.
Neither party can just withdraw unless there's a breach, like an unmet conditional condition. It's a firm commitment.
And if the purchaser doesn't exercise the option in time, what happens then?
If the OTP isn't exercised within the validity period, it just lapses, becomes null and void. Neither party has further claims regarding that sale. Importantly, the vendor gets to forfeit and keep the option fee paid by the purchaser, like a non-refundable reservation fee.
Precisely. Now, a very significant aspect of most Singapore property contracts. The Law Society of Singapore's Conditions of Sale 2012. What are these and why are they so important?
Think of these Law Society conditions as a standard set of terms, 16 clauses total, very commonly incorporated into property sale agreements, or OTPs here. If the main agreement is silent on something common, these conditions step in to provide a framework.
Fills the gaps, basically.
Exactly. But importantly, these standard conditions can be modified or overridden by express terms specifically negotiated in the main contract.
So a baseline framework, but the signed agreement's specific clauses take precedence. And where can our listeners, the aspiring RES agents, find these crucial conditions of sale?
Our notes helpfully point to the Law Society website. You can download a copy for free. The link is http://www.lawsociety.org.sg for Members Resource Center Conditions of Sale 2012.ASPX. Definitely worth downloading and study. Understand both sides' rights and obligations.
Agreed. Let's highlight some key obligations these conditions place on the vendor.
Okay, vendor obligations.
Big one.
If the buyer's check bounces, the vendor can choose to rescind and forfeit the deposit or affirm the contract and demand completion. Payment needs to be secure. They're also entitled to rents profits up to completion. They must provide original title docs for inspection, usually a month before completion, and deliver the property in the same condition as at the option contract date, fair wear and tear accepted.
And don't forget removing movable items not included in the sale. Paying outgoings like tax and maintenance fees up to completion, plus any applicable GST. They're also liable for any income tax on gains.
Right.
Plus, indemnifying the buyer against tax claims, notifying buyer about any seller's stamp duty SSD payment evidence 5 days before completion, no unauthorized alterations, and the property not transacted at undervalue within 5 years. Quite a list.
Definitely paints a clear picture. Now, the flip side, key obligations on the purchaser under these conditions.
Purchaser's main duties are financial. Paying all applicable stamp duties, BSD, maybe ABSD, possibly deducting and paying withholding tax to IRAs if the vendor is non-resident.
Okay.
And crucially, if the sale triggers SSD for the vendor, the purchaser might need to deduct this from the price, pay it directly to IRAs for the vendor, and provide proof if asked.
So, fair bit of financial admin for the buyer, too. Any specific clauses within these Law Society conditions that RES exam takers should really focus on?
Yes, several stand out. Conditions 1 and 2 on paying conveyancing money are vital. They state all monies, deposits, balance, GST, stamp duty, CPF funds must go to the vendor's solicitor's conveyancing account, CVY account, ensures secure, traceable funds flow.
Streamlines the finances through proper channels. What else?
Conditions 7.4 and 7.5 on stamp duty liability reinforces the vendor's duty to tell the purchaser about any SSD liability under Section 22A of the Stamp Duty Act, allows the purchaser to potentially deduct and pay SSD to IRS directly, providing proof, ensures compliance.
Transparency and proper handling of duties. Essential. What about delays in completion?
Conditions 9.1 and 9.2 cover late completion interest. Notably, the rate was revised from 10% down to 8% per annum, payable by the party at fault for the delay. Reflects market rates.
Good to know the current rate. And if a buyer's check bounces, that can mess things up.
Condition 4.0 deals with that. If a payment instrument is dishonored, the vendor has options: rescind the contract and forfeit the deposit, or affirm the contract and pursue the sale. This applies regardless of why it bounced.
Puts the onus on the buyer to ensure payments are good. What about the property's physical condition at completion?
Conditions 5.1 and 5.2 state the vendor must deliver the property in the same state as at the option contract date, whichever was earlier, fair wear and tear accepted. If sold with vacant possession, all movable items must be removed unless agreed otherwise.
So no finding the seller's old sofa unless it was part of the deal. And who covers ongoing costs like property tax and maintenance fees leading up to completion?
Conditions 6.1, 6.2, and 6.3 address apportionment. Unless the OTP says otherwise, the vendor covers costs and gets rent profits up to and including the completion date. The purchaser takes over from the day after completion. A clear division.
Makes sense. Clear cutoff. Now let's move to just before the handover rights and duties leading up to legal completion.
Right, legal completion. That's the final stage. Property conveyed, buyer pays the balance, gets keys, usually at the vendor's solicitor's office. The date is fixed in the contract.
So, purchaser's rights and duties in this pre-completion phase.
Main duty: have the balance ready for payment on the completion date. They also cover expenses for transferring the title. If a notice to complete is served by the vendor due to delay, we'll get to that, the buyer usually has 21 days to finalize.
Okay.
If the vendor fails to comply with a notice served by the purchaser can demand their deposit back. In serious vendor defaults, the buyer might even pursue specific performance, a court order forcing the sale.
And the vendor's rights and duties in this period.
Vendor ensures conveyance documents are prepared and executed. They must complete within 21 days if they receive a notice to complete from the buyer. If the purchaser defaults after a notice, the vendor can forfeit the deposit, resell the property, and claim losses from the defaulting buyer within a year. If they resell for more, they usually keep the surplus.
So, both sides have critical obligations for a smooth completion. Now, tricky situation. What if the property gets damaged between contract signing and legal completion? Who bears the risk?
Generally, the risk stays with the vendor until completion. They should maintain insurance. The only common exception is if the buyer takes early possession, then risk usually shifts to the buyer, and they need insurance. Law Society Condition 5.1 reinforces this unless the OTP states otherwise.
So if a big storm damages the roof the day before completion, that's usually the vendor's problem.
Correct. If the damage is substantial, making the property not essentially the same, the buyer might even rescind the contract. If it's less severe, like a burst pipe, the buyer usually has options. Proceed but negotiate a price reduction for repairs.
Seems fair. What should the buyer do if they discover damage before completion?
Best step: immediately tell their solicitor. The solicitor can then formally notify the vendor's solicitor. This gives the vendor a chance to fix it, or if not, allows the buyer's solicitor to advise on claims against the vendor's insurance or maybe small claims tribunal for minor stuff. It circles back to Condition 5.1. Prompt communication is key.
Agreed. Communicate immediately. Get lawyers involved. Now, strata-titled properties again. When a condo unit sells, how are ongoing fees and taxes typically split?
For strata properties, recurring fees and taxes are usually apportioned based on the completion date. This includes management fees, sinking fund contributions plus any GST, rental income plus GST if applicable, and property tax.
Okay.
Standard practice, vendor responsible up to and including completion date gets rent for that period. Purchaser takes over from the day after. It's prorated based on the handover.
A fair, proportionate sharing, then.
Exactly. Unless the OTP specifically says otherwise, any GST on the sale itself is usually borne by the purchaser. Stamp duty liability, ABSD, BSD, SSD is determined by the Stamp Duties Act. For specifics on apportionment, refer back to Law Society Conditions 6 and 7.1.
Right. The OTP can override general rules, so careful review is vital. Now, we mentioned it. Let's dive into the notice to complete. What is it, and when is it issued?
A notice to complete is a formal written notification. Either party can issue it if the sale isn't completed by the scheduled date, but the vendor can only issue it to the purchaser after at least 5 clear business days have passed since the vendor gave payment method details, ensures the buyer had time to arrange funds.
A formal nudge, then. What happens once a valid notice is served?
Once served, the receiving party gets a strict deadline, usually 21 days, to complete their obligations. Time becomes legally of the essence. That deadline is critical. Failure has major repercussions. But even after a notice, both parties keep any existing rights to rescind if there are other valid legal grounds.
And if the purchaser fails to comply with the vendor's notice?
They must return title deeds and other documents. They pay for canceling any contract entries in land registers. The vendor can forfeit the deposit, resell the property, and claim losses from the resale within 1 year. If the vendor resells for more, they keep the surplus.
Significant remedies for the vendor. What if the vendor fails to comply with the purchaser's notice?
Purchaser has options. First, immediately pursue legal remedies like specific performance, no further notice needed. Or give written notice demanding immediate repayment of deposit and other monies paid without prejudice to claiming further damages.
Okay.
If the vendor repays, the purchaser usually loses the right to specific performance, must return title deeds, and the vendor pays for canceling contract entries.
It sounds like a final ultimatum. Is that 21-day deadline rigid? Any flexibility?
Yes, the party who served the notice can choose to extend it for specified periods if they want to be accommodating or circumstances warrant it, but any extension should really be documented in writing.
Good to know there's potential flexibility. Now, shifting to strata-titled properties and the crucial Building Maintenance and Strata Management Act, BMSMA, essential knowledge for condo sales.
Absolutely. Understanding key BMSMA provisions is vital for advising clients and navigating issues. Let's start with Section 32, Bylaws for Common Property.
Bylaws, the rule book for condo living.
Yeah.
Main points.
Every strata plan has them. For MCs formed after April 1st, 2005, prescribed bylaws apply automatically. Any MC-made bylaws can't contradict these. MCs can make amend bylaws via special resolution for safety, restricted areas, pets, parking, appearance, etc. They only take effect after lodging with the Commissioner of Buildings. They bind the MC, owner, subsidiary proprietors, mortgagees in possession, tenants, occupiers.
Okay, binding on everyone living there.
Right. MC must keep records, display them, provide copies for a fee. But bylaws cannot restrict selling, mortgaging a unit, or interfere with easements. Courts can enforce bylaws or award damages for breaches, and lease includes tenancy agreements here.
Comprehensive rules. What about owners wanting to improve their own unit? Section 37.
Yes. Generally, no increasing floor area without MC authorization needs a 90% resolution, a very high bar. Other improvements affecting building appearance also need MC authorization if they don't maintain the look or affect structural integrity. Floor area definition follows the planning rules.
So no adding balconies without proper approval. What about financial contributions for upkeep? Section 40.
Exactly. Section 40 lets the MC levy contributions for maintenance and sinking funds via written notice, usually proportional to share value, with some exceptions.
What if someone doesn't pay?
New owners can be jointly liable for previous owners' unpaid dues. Past owners remain liable too. Mortgagees in possession can also be jointly liable. Contributions are due without deduction. Late payments over 30 days incur interest at the MC's rate. Unpaid amounts plus interest can be recovered as debt in court, even small claims. MC can issue a formal demand. Failure to pay within 14 days of demand is an offense, fines up to $10 plus a 100-day ongoing. Court can order payment too. And subsidiary proprietor includes mortgagees in possession and those receiving rent. Paying MC fees isn't optional.
Definitely serious consequences. What about owners accessing information about the MC, Section 47?
Yes, Section 47 ensures transparency. Upon written application and prescribed fee, MC must provide info. Names of chairperson, secretary, treasurer, managing agent details. They must also let owners inspect documents, strata roll, notices, plans, meeting minutes, accounts, etc., and certify details like contributions payable, unpaid amounts, interest, court orders. Collective sale committees also have rights to strata roll extracts.
Okay.
Certificates issued by the MC are conclusive evidence. Owners can take extract copies but can't remove originals without consent.
Clear mechanisms for owner access then. Now, subsales of completed properties. When the original buyer sells before completing their own purchase.
Good definition. A subsale happens when the original purchaser, OK, wants to transfer their rights under the original agreement to a new buyer, SP, before OP completes their purchase from the original vendor, V. Could be adding a name, assigning interest, or flipping for profit. Crucially, whether this is allowed without V's consent often depends on whether the original OTP from V to OP included and/or nominee.
And/or nominee. Those three little words again. How do they affect things?
If the original OTP has and/or nominee after OP's name, OP generally can assign their rights to a nominee without V's further approval, unless V specifically struck out and/or nominee when issuing the OTP.
So if V struck it out.
Then OP generally cannot flip the property by assigning the option without V's express consent. Prevents speculation sometimes.
So it hinges on the original OTP wording. Are there property types where and/or nominee is always banned?
Yes. The notes say it's prohibited in OTPs under the Housing and Developer Act, New Private Residential, Sale of Commercial Property Act, and HDB transactions. No assigning options there.
Important distinction for the exam. Now, if a subsale is allowed, and/or nominee included and not struck out, what's the process like?
It involves V, OP, and SP. Starts with option 1, V to OP. OP might then give option 2 to SP, but option 2's expiry must be same day or earlier than option 1's. Often, when OP exercises option 1 or signs S&P 1, SP exercises option 2 the same day. Or OP might grant option 2 after exercising option 1, or sign a separate subsale S&P 2 with SP.
Seems complex timing.
It is. The legal completion, V transferring to SP, must happen either simultaneously with the V to OP completion or later, as agreed. Leading up to completion, OP's lawyers lodge a caveat, prepare a tripartite transfer doc for V to sign, transferring directly to SP. SP's lawyers also lodge a caveat, do checks, and prepare other docs, including that tripartite transfer instead of 2 separate transfers. Finally, completion of both original sale, VOP, and subsale, OPSP via direct VSP transfer, happens simultaneously. It requires careful coordination but allows transfer before OP becomes registered owner.
Definitely sounds intricate. Lots of coordination needed.
Absolutely. Effective communication and meticulous legal work are crucial for a successful subsale.
Well, Serene, we have truly navigated a vast landscape today. We covered Caveat Emptor, title verification, handling money, misrepresentation liabilities, sale procedures, OTP intricacies, law society conditions, pre-completion rights duties, property damage, apportionment, the notice to complete, key BMSMA points, and finally, subsales.
Indeed, Damien, a very comprehensive overview for your RES exam prep on completed private property sales. Remember to revisit these concepts, review your notes, maybe look at source materials again.
And that brings us to the end of this session of Real Estate Salesperson's, aka RES, exam prep. We sincerely hope this deep dive has been valuable, boosted your confidence in the exam. Remember, thorough prep is key.
We extend our very best wishes to all of you for success in your upcoming RES exam. Study hard, stay focused, and you'll do great.
Yes, from both Serene and myself, Damien, sending positive vibes. Go forth, show your knowledge, and conquer that exam. You've got this.